Hello and welcome to the program. I'm Simisola Atiku. The federal government has warned the 36 state government against entering foreign or international negotiations without the input of the Ministry of Foreign Affairs. The Minister of Foreign Affairs, Yusuf Tuga, made this known following the dispute between the Ogun State government and the Chinese firm Zhongshan Fusheng Industrial Investment Company Limited after a 2007 deal for the setting up of a free trade zone collapsed, resulting in arbitration and the seizure of Nigerian jets and also other properties around the world. The action was strongly condemned by Nigeria because sovereign assets were outside the scope of assets that could be attached to the judgment debt. To prevent such issues in the future, the Foreign Affairs Minister says it is very significant to register international agreements with the federal government, embassy and Ministry of Foreign Affairs. This is part of what the minister said.
Yes, the Attorney General and I are working on it, both diplomatically and then from the legal perspective as well, to ensure that this issue is resolved. But you see, again, this is part of the problem when subnational actors like state governments take it upon themselves to go into agreements, go into international arrangements without recourse to the Ministry of Foreign Affairs, without recourse to the federal government, and then when it goes awry, we are left with the problem to deal with. And that is why it's always important that such arrangements should be registered with the mission there, with the embassy, with the Ministry of Foreign Affairs, and with the federal government. This is something that Ogun State, under a different administration, not this governor, entered into that we're not aware of. All we know is that, they're going after Nigerian assets. That's why really foreign or international negotiations is not the purview of subnational actors. You should always have those that are experienced in such an area, that have the necessary skills and the necessary training to negotiate these sort of agreements.
Now, despite an independent arbitral tribunal awarding Zhongshan approximately $74.5 million, the Ogun State government has disputed the decision and has not yet honored the award. Well, joining me to discuss this further is legal expert Fred Nzako. Thank you very much for joining us, sir. Now, this warning issued by the Foreign Affairs Minister to the 36 states of the Federation to get the Nigerian government involved when dealing with international companies. First of all, how serious is this case between the Ogun State government and that Chinese firm? And does it not limit the authority of state government authority in ensuring development in these states?
Yes. When you talk about international, the name alone tells you that it means between and among nations. International can be bilateral, international agreement can be bilateral or multilateral. Bilateral when only two countries or two nations are involved, and multilateral when more than two nations or two countries are involved. And the word international covers both bilateral and multilateral agreements and relationships. So when you use the word international, you are not talking about subnationals. A state is a subnational entity within a national sovereign, in which case it is not a national sovereign and cannot engage in international agreements or international relationships without the endorsement or the approval or permission or cooperation of the national sovereign of which the state is a part of. In this case, Ogun State is a subnational of Nigeria. Nigeria is a nation, and Ogun State cannot enter into an international agreement of any nature without Nigeria as a country standing behind its subnational. The country represents the father. The subnational or the state represents the son or the daughter, if you may like. So the son or the daughter cannot go into a multi-family relationship without the consent or the endorsement of the father. If you bring it down to the minutest family unit, that is what it looks like, and that is what it represents. So no state will go into a bilateral or multilateral agreement without the endorsement or the backing of the sovereign country, because international relations, international diplomacy does not contemplate the participation of subnationals or the states at the exclusion or without the participation or the consent of the nationals that are recognized sovereign entities in international diplomacy and international agreements. So Nigeria is not an exception. And the state of Texas cannot go into an international agreement with Nigeria without the United States being part and parcel of it. And so it is all around the world. Whether the state is referred to or the subnational is referred to as a province or a state or a region, it does not have a sovereign national entity or authority to go into international agreements without that country that has that national sovereignty backing it and being part and parcel of it. And we have seen that play out in the matter between Ogun State and the Chinese company in their international agreement. Nigeria was involved. Nigeria as a country was part and parcel of it. Nigeria gave it an endorsement in two ways. One, by way of bilateral agreement with China, which was struck in 2001 under President Olusegun Obasanjo. And it's on the basis of that bilateral agreement that the Chinese company now came to Nigeria to engage in business with a subnational of Nigeria with the backing of Nigeria. So the second way where Nigeria was involved was that to establish and operate a free trade zone or an export processing zone, the Nigerian Export Processing Zone Authority, NEMSA, must give it its authorization because it is the authority that handles anything about free trade zone or export processing zone. And it is a federal government agency. It is like Federal Airport Authority of Nigeria, that is the authority in charge of Nigerian airports. And you have similar authorities and similar statutory organizations in handling other industrial and segmented issues and markets in Nigeria. So, going by the foregoing explanations, it is given, it is understandable that no state in Nigeria should engage in international agreement with another company of another country or another state of another country or another sovereign country without expressly being supported and backed up by Nigeria as a country. What Nigeria is trying to do now is only to make it an express authority, an express pronouncement, an express policy. Otherwise, the one that embarrassed us recently, Nigeria was part of it. It's not as if Nigeria as a country did not know about it. Ogun State did not enter into such agreement without any part of the federal government knowing about it. At least NEMSA was aware. If the Federal Ministry of Industry did not know, if the Office of the Attorney General and Minister of Justice of the Federation did not know, at least Export Processing Zone Authority must be aware. And by the time they went to arbitration, I'm sure that Nigeria must have been served. And by the time they even went to court, I'm sure that Nigeria, having been joined as a party to that suit or a defendant in that suit, must have been aware. So there is nothing new in that agreement that the federal government of Nigeria did not know. And they may not know all the details, but at least they were aware, especially when the agreement became contentious when it was terminated by Ibikula Amosu administration in Ogun State. So it is supported that for any state or any subnational entity in Nigeria to go into an international agreement with any other entity outside Nigeria, the federal government must be put in the picture. And then for them to sign any agreement, it is recommended that the Office of the Attorney General of the Federation should at least know what they were signing, not to meddle into the agreement, but at least to make sure that there's no repeat of this kind of embarrassment that Nigeria went to in the hands of Chinese company.
This is not the first time a state government will sign a contract with an international company. For instance, we have the Lagos state government and the China Civil Engineering Construction Corporation Limited. It's a Chinese company as well, in charge of building the metro, train stations and other infrastructure. And, you know, both entities have had smooth running interaction. How come it's a different ball game for the Ogun State government? I mean, what went wrong in the course of their agreement?
Yes, the metro line project of Lagos State and by extension any other state for that matter may have been, let's say your question was specific about Lagos and Ogun. And the federal government did not have to negotiate the deal with Lagos State. Recall that under our constitution, we have 3 tiers of government: the federal, the state, and the local. And as much as possible, we try to give semi-autonomy to every state to operate its affairs. And that is why you have elected leadership at every state level, at every subnational level, where you have the governor, you have the House of Assembly, and you have the state judiciary. The same way you have at the federal level, and the same way you even have at the local government level. So every tier of government is authorized and mandated by the Constitution to enter into any agreement that will foster the development and growth of the state, as the case may be. The only thing is that when such agreement has to involve an international organization, be that international company or another government outside Nigeria, then the federal government of Nigeria should be aware, because the state as a subnational does not have a sovereign status outside that. It derives its authority from the sovereignty of Nigeria as a country. And that is why once an organization or an entity outside Nigeria is involved, the federal government should be taken along and should be part and parcel of the whole process, especially with respect to issues of agreement and the rest. But if that organization is within Nigeria, it does not need an endorsement of the federal government for the state to go into such an agreement. If my company has something to do with Ogun State government or with Lagos State government, I do not, because I'm in Nigeria and my company is a Nigerian registered organization, I do not need federal government presence or even interference or knowledge or undertaking for my organization to go into such agreement. And that is the difference. The difference lies in the origin of the company that is going into such agreement with the subnational, with the state. The Metro Line project is being run by Chinese company. And such Chinese company is outside Nigeria. So obviously, while Lagos State will negotiate with the company, the federal government should be aware of such negotiation and the financial implications, such that if there is any untoward development that arises along the line, the federal government will not be taken aback. Rather, the federal government should know exactly what to do, and so as to save Nigeria from international opprobrium, from international condemnation, or from international issues that may arise if the subnational of Nigeria does not play by the rules of the game.
Well, Mr. Nziako, we'll take a break, and when we return, we'll continue this discussion. Do stay with us. Welcome back. We're still discussing the directive by the Minister of Foreign Affairs to state governments against contract agreement with foreign companies behind the federal government, or rather without the input of the federal government. Legal expert Mr. Fred Nziako is still my guest on the program. Thank you very much for staying with us, sir. Now, considering the international embarrassment that this controversy has brought to the Nigerian government, are there any implications legally, that is, or sanctions for the actions of the Ogun State government?
Well, the legal implications are multidimensional. Number one, the issue is about money. Money is the problem. There's no security challenge. Neither is there any issue that arose from the agreement that harassed Nigeria's sovereignty or territorial integrity. It's all about financial and monetary issues. And Ogun State, as a subnational, goes to Abuja every month to collect its own share of the national cake, which is called the allocation from the Federation Accounts Allocation Committee. So if they fail to pay the Chinese company, the federal government has a place to hold Ogun State to account by deducting the money due to Ogun State at source and pay the Chinese company, and then save Nigeria from further embarrassment and from further seizure of our national assets outside Nigeria. The second legal implication is that it was not Ogun State as a state that embarrassed Nigeria. It was the governor of Ogun State. When a state, under company law, there's what we call the doctrine of lifting the veil. When a company has done something, and then you have to go beyond the veil of the company to get at the personality of the directors of the company. When a state has done something untoward, you go beyond the general facade of the state to get at the functionaries and the officials and leaders of that state. In this case, you have to go beyond Ogun State as a state and get to the governor, the then governor, Senator Ibikula Amosu, who caused this problem. By the time you get to him, then issues will begin to arise. Whether that cancellation of the contract was done by the State Executive Council, was there a place where it was discussed by the Executive Council, and then the council now approved on behalf of the state that the contract be cancelled? It is now the duty of Amosu to free himself. He has to bring the evidence. He has to present his own defense and give reasons why he cancelled that contract that now has brought the problems. Was there any time that the State House of Assembly, as a representatives of the people, asked the governor to cancel the contract? And all those things will now come to the public domain. Who took that decision that the agreement be cancelled? Was that the House of Assembly? Was that the State Executive Council, or was that a unilateral decision by the governor himself? If the governor acted by himself and not in cahoot with the other organs of the state, then the then governor will now be called to question. And if there are sanctions, the sanctions will go to him. Of course, because he acted as a governor, the state will share in that sanction by way of deduction from federation account. It is now the state that will now fall back and hold their governor to account because their governor acted not in their very best interest, but in his own personal capacity as the governor. And if he succeeds in convincing the state that he acted in their best interest, then it is left for the state to decide and let him go scot-free. But if he fails to do so, to convince the state that his action was in their best interest, then the state will have a way of bringing sanctions to him, either by way of confiscating his own personal assets to restitute the state, or charging him to court, because now he no longer enjoys immunity. He is now an ex-governor and no longer a serving governor. And of course, the doctrine of immunity expires the very day the governor steps down from office. And the governor can now be called to give account. And that is why the EFCC can drag former governors to court on account of the actions they took while in office. The state as well can drag the governor to court on account of the action he took while in office. Those are the legal implications, and those are the areas of restitution that can come to both the state and to Nigeria as a federation.
Well, let's hope that the Nigerian government is able to handle this situation without it causing too much harm. A legal practitioner, Mr. Fred Nzako, thank you very much for sharing your insights on this topic. That's how much we can take on this episode of the program. We'll see you again next time. Bye for now.